Senses, at least as I understand them, and because I haven't.
Right from this opening exchange, we immediately see the tone Judge Simpson is setting. Before the facts of the case even unfold, the issue becomes courtroom conduct. And that matters more than many viewers realize. When someone represents themselves, as this defendant is attempting to do, judges have to strike a delicate balance, allowing personal defense while still maintaining strict courtroom decorum. Judge Simpson's warning isn't personal, it's procedural. Courts run on order, not emotion. Interruptions or challenges to rulings, especially delivered emotionally, can quickly derail proceedings. And when that happens, judges may revoke freedoms already granted. Notice how the judge quickly reminds the defendant that bond conditions and freedom are privileges that can disappear if courtroom behavior spirals. Then this opening moment sets up the entire drama. A frustrated defendant, already under scrutiny, trying to navigate a complex legal system without counsel. That combination often leads to tension, misunderstandings, and decisions made out of frustration rather than strategy. And here's a question for you watching. If you felt the judge misunderstood you, would you speak up and risk angering the court? Or stay quiet even if you felt treated unfairly? Because from here on out, every decision, emotional or legal, starts to stack consequences, and we're only getting started.
Heard the entirety of the case or anything.
Right, exactly.
I'm
Probably
going,
pause or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That can set a bond violation hearing April 16th, 2024 at 2 p.m. At 2 p.m. There anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tether division. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. And big, yeah, I can't afford cash bonds or something, just write a beer out on them, maybe sign that, got it, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
Here's where confusion begins to hurt the defendant's position. The judge is trying to keep the discussion focused, but the defendant seems unsure how bond hearings and violation proceedings actually work. And this is critical. Courts separate hearings by purpose. Today isn't about guilt or innocence on the main charges. Today is about whether bond conditions were violated. A bond violation hearing is much simpler legally. The court doesn't need proof beyond a reasonable doubt, only enough evidence to show a violation likely occurred. That's a much lower bar. So when the defendant keeps circling questions about timing or fairness instead of directly addressing the violation, it frustrates the judge and weakens his own case. The judge explains that each appearance addresses the issues scheduled for that day. Violations get handled first. Charges get handled later. But without legal training, defendants often think everything can be argued at once. That misunderstanding can cost them credibility in front of the court. And credibility matters enormously. Judges ask themselves one main question: can this person follow rules if released? If the answer becomes unclear, bond freedom disappears quickly.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you. Court does call the case of the people state of Michigan versus Cody Lee Jolly. Your name, sir?
Cody Lee Jolly.
This is a bond violation hearing. Miss, please go ahead.
Before we begin, I do have a copy of the police report outlining the violations, a copy of the complaint of violation release, and 3 photographs all to give to the defendant so that he could review them before. There's a.
All right.
Thank you.
Mr. Jolly, you had an opportunity to look through all of that?
Yeah.
All right. So let me ask you this. Do you still wish to continue with the hearing, or do you wish to admit to a violation of your conditional bond? As the court understands that there would be 2 potential violations, the violation of the substance abuse or substance provision of your bond. The other would be not to commit any crime, as there is the crime of trespassing, which has occurred or appears to have occurred.
This is a turning point. The judge explains that bond conditions don't require someone to be newly charged with a crime. Just committing one is enough to violate release terms. And many viewers misunderstand this. The defendant argues he wasn't formally charged with trespassing, so why should it count? But bond rules operate differently. If evidence suggests someone committed an offense, even without immediate formal charges, the court can still consider it a violation. This matters because bond isn't punishment, it's trust. The court releases someone under the assumption they'll follow rules while awaiting trial. When that trust breaks, the court doesn't need a full criminal conviction to react. The defendant's confusion here shows the difficulty of self-representation. He's thinking in terms of criminal charges, while the judge is thinking in terms of compliance. 2 different legal tracks. And let me ask viewers, do you think someone should lose bond freedom only after being formally charged, or is suspicion of violation enough? Because courts prioritize public safety and rule compliance even when cases are still pending.
Well, question, I guess, then, but just if I wasn't charged with trespass and stuff, right? Because I've not been.
I understand that.
Okay, so then would that technically come into play as legally? As
The condition of the bond is that you not commit any crime.
Right.
Trespassing can be crime. Doesn't matter whether it's charged.
Okay.
It won't for the court's consideration.
Okay. Sure. Okay.
So what do you wish to do?
I mean, I don't, I guess I mean, I admit that there was probably weed on me that was still there. I didn't know that much weed on me. That was still there. And, yeah, I don't know about the trespass. I don't know how it comes in.
Well, you had been read trespass before, correct? I mean, you don't have, pardon?
I never remember that.
So if the court understands it, correct me if I'm wrong, I mean, you can certainly look at it, that you had been read trespass from University of Michigan properties before?
I think due to this, I guess due to this kid ongoing case, because I have a
Right, but
hold
hold on.
They said that it's just this case. I've already, I'm.
Right, but Mr. Jolly, my point is that you've been read trespass from from University of Michigan, right?
Yeah, but I'm in, court paperwork with them. I've argued it.
Okay, all right, then let's,
Pretty cool.
all right, you want to go around and round about that, I won't
It's okay.
necessarily go round and round about it. I mean, you admit to violating the substance provisions. You do admit to that.
Correct. I was at the library.
All right. Pardon?
I was at the library.
Right.
Correct.
And would you admit that you shouldn't have been on the library property?
Yes. Yeah.
Because you had been trespassed before, right?
From the, right. Yeah. All the stuff. Right.
Right? Okay. All right. So you're admitting to those violations.
Right.
This admission is huge. Once the defendant acknowledges both substance-related violations and being somewhere he wasn't allowed, the judge's options narrow quickly. Admissions in court are powerful because they remove factual disputes. The court no longer needs to debate whether violations happened, only what consequences follow. Now the hearing shifts from "did violations occur" to "should bond continue." That's a much tougher battle for the defendant. His argument focuses on fairness and time already served, but judges focus on risk and compliance. From the judge's perspective, if someone violates conditions once, what prevents them from doing it again? Courts don't want repeat violations while cases are pending. So admissions, even if honest, can unintentionally strengthen the court's justification to revoke bond. This moment highlights how honesty in court can sometimes clash with legal strategy, especially without legal counsel guiding responses.
I expect everybody to come down. All right. I will accept those admissions to that. Now, you wanted to argue your bond, sir, given the violations?
Yeah. My thing was just that I'm still going through the court process trying to get the trial. I've already done 2 months on this tether. I've done over 2 weeks, done like 15 days so far in jail, and I haven't been to trial yet. So my hope was that with all that time served and not being convicted yet, that I could just go back and to being a regular citizen, treated fairly, and await trial.
All right, and I'll certainly hear from people, but here's the court's concern with releasing you. You originally were released on this case, right? And then shortly after being released, you're in violation of the conditions of your release. Right?
I don't know that. This has been 2 months.
Well, you just admitted to violation. Well, but you just admitted to violations, right? Right?
Right.
Okay. So what tells me that if I were to release you, that there wouldn't be other violations of your condition?
That's kind of what I'm asking, is that if you could remove the conditions, because I haven't still going through the court process. My thing is I don't have money to.
No, Mr. Jolly, you don't understand how this works. You were released, okay, with certain conditions regarding your release, right? Right?
Right.
Okay. So you were free to do what you needed to do as long as you abided by those conditions, right? That's where you were.
Right.
Then at some point, you violated those conditions.
Right. It's been 2 months.
Okay, but it doesn't matter. You violated the conditions. Right? Okay. Now, Mr. Jolly, here's the problem. If you think for one moment that even if I were considering your release, that I would release you without any conditions, that's not going to happen.
I'm just trying to.
So then the question becomes, Mr. Jolly, when you say you want me to release you, How can you assure the court that you will abide by the conditions that have been set?
Judge Simpson now draws a firm legal boundary. Bond without conditions almost never happens in cases involving alleged violations. The defendant hopes for freedom without restrictions, but courts rarely take that risk, especially after rules were already broken. Notice how the judge keeps returning to one key question. What assurance exists that violations won't continue? Bond isn't about punishment. It's about guaranteeing court appearances and community safety. Conditions like tethers, substance restrictions, or location bans exist to reduce risk. The defendant frames the situation emotionally, arguing fairness and presumption of innocence. And legally, he's right. He is presumed innocent. But bond decisions operate independently from guilt or innocence. They revolve around compliance and risk management. And this disconnect, emotional fairness versus procedural caution, is where many defendants struggle. Judges must think long-term consequences, not momentary sympathy.
Just the fact that I'm a law-abiding citizen, besides the fact that I'm guilty of this, I have no proof that I haven't been convicted, guilty of this, no proof that I did. Besides this ongoing plea, I'm a law-abiding citizen, so I just ask for being considered innocent.
Sir, you are considered innocent until proven guilty, but the court also has the ability to set your bond and give conditions. All right. The court initially did that, and you violated those conditions.
Yeah, no, I understand what you're, I think a lot, I do my best when I get out. That's when I get out, I'm a law-abiding citizen, I don't.
Here's what I'm gonna do. Was there anything from the people?
A couple of things. So what I didn't realize, and I apologize, but I wasn't reading the report properly the last time we were here. It's 2 events that he's back at the library. So when I was speaking with the office beforehand, they made that abundantly clear to me.
That there were 2 times that he was,
Yeah, and at 2 separate libraries. So I'm not really sure what's going on under.
What do you mean, what's going on? Oh, are there things out there again? It was balloons? So there's this filter thing, and we're trying to figure out where it comes from. We'll sort that out. But the balloons are pretty, I bet. They were. Okay.
So it's 2 April 3rd at 5:55 p.m. He was there. He was looking at according to the police report, he was looking at pornography at a public computer that he was suspected of masturbating. I asked the officer who's here to give me additional details about that. And I believe the information I got was that the witnesses believed he was masturbating, perhaps that his pants were in a certain position, that he was rubbing his genitalia underneath his clothes, which is similar to the events of the April 5th in the sense that when the police get there, he's not actually exposed, but certainly conducting himself in a way where he's got his chest exposed.
Now the prosecution introduces details that dramatically shift perception. Allegations of inappropriate behavior at a public library while already on bond create serious concern for the court. And remember, this isn't a trial yet. These details influence bond decisions, not guilt determinations. The prosecutor builds a broader narrative: repeated incidents, criminal history across multiple states, substance abuse concerns, and prior offenses. For a judge deciding whether someone can safely remain free, that pattern matters more than a single event. And here's something viewers often miss. Judges look for behavioral patterns, not isolated mistakes. When violations appear repeated, courts assume future violations are likely. So even if the defendant sees his situation as misunderstandings stacking up, the court sees escalating risk. That difference in perspective often determines outcomes in hearings like this.
Outer layer of pants pulled down. And this is a CSC case. So it's like, well, we take that behavior and then we layer it on with the fact that he's out on bond for assaulting nurses at the U of M hospital, and he's now charged with CSC for his sexual assaults on them. But in response to the I'm a law-abiding citizen, I mean, I'm looking at his criminal history from Florida. I'm looking at his criminal history from North Carolina. I'm looking at his criminal history from Michigan. The majority of what I'm seeing are misdemeanors, but I do have carrying a concealed weapon from North Carolina. There are larceny offenses from North Carolina. And
No.
well, there are. I'm looking at them right now.
Sir, hold on.
In Florida, there is a charge of battery, touch or strike. It was a misdemeanor assault, is what I would probably call it here. Resisting obstructing the police, which is clearly listed as a felony. In Michigan, which seems to be his most recent history, it appears that substance abuse is an issue. In 2010, he was convicted of operating while intoxicated. In 2011, there's a minor in possession that is still listed as a bench warrant. I don't know what that's about. Out of the 90th District Court. 2016, retail fraud conviction. 2017, a conviction for use of controlled substance. That looks like it was pled down from a possession of of dangerous drugs. Is what it is initially entered at. But all to say that this is not somebody who has no criminal history. This person's criminal history spans across at least 3 jurisdictions. So, Your Honor, at this point, I'm asking you to not release him. I do also have a question, though, however, about the tether.
Yes.
What type of tether? Like, so I don't have notes from his the person that arraigned him did not put notes in his file.
At this stage, the prosecution has done what it needed. Present enough history and behavior to argue continued detention. Now, the judge weighs everything: admissions, conduct, prior history, and risk. Bond decisions are less about punishment and more about predicting future behavior. The court must ask, if released again, will this defendant comply? And based on what we've heard, the judge clearly has doubts. Viewers sometimes think judges act harshly, but remember, if someone released on bond commits another offense, public backlash falls directly on the court. Judges must be cautious. Here's a tough question for viewers. Should courts prioritize second chances for defendants, or focus strictly on preventing further risk to the public? Because balancing compassion and caution is one of the hardest parts of criminal justice decisions.
And when I look it up in JIS, you see that it was tether.
It is not a. It's not a GPS tether. He's simply on a scram.
Oh, thanks, Your Honor.
All right. Anything else you want to say? At this juncture, I'm going to continue the defendant, given the circumstances of this case. The bond violation has been found, and the defendant's bond will continue as revoked. You were set for, I will review that again, but you're set for preliminary examination in this matter this upcoming Tuesday, the 23rd, so a week from today. Pardon?
Do my bond on that day.
I will look at it after I hear testimony in the case. But at this point, your bond will continue as revoked. Thank you.
Thank you.
And here we reach the conclusion of this hearing. Judge Simpson determines the bond violation stands, meaning the defendant remains in custody while the case moves forward. Importantly, this is not a conviction. The defendant still has upcoming court dates, including the preliminary examination, where actual evidence and testimony will be evaluated. The professional takeaway here is clear. Bond is conditional freedom. Violating those conditions, whether through new incidents, prohibited conduct, or failure to follow restrictions, makes courts far less willing to grant another chance. Self-representation added complexity, as misunderstandings and emotional responses weakened the defendant's arguments. This case shows how courtroom behavior, compliance with bond rules, and personal history all influence outcomes long before trial begins. Judges must balance fairness with public safety, and once trust erodes, regaining freedom becomes difficult. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.